Okay, so today we'll look at charges. We'll look at charges. Now, charges is very important. It's like the most important topic in criminal litigation because, like I said some time ago, you usually see it as the number one question, either 25 marks or 20 marks, depending on how they feel for that year. So, when we talk about charges, we are talking about basically the statement of offenses. You understand? We're talking about the basically the statement of offenses with which a person is tried with in court. Charges refers to that document containing the offenses for which a person is being tried in court. Like the foundational scenario I gave, Musa committed the offense of stealing. They have investigated Musa, they have searched his house, they have conducted pre-trial investigation. So now Musa is in court. You understand? Musa is in court. Oh, sorry, Musa. Musa is not yet in court, but then we want to know how to draft his charge sheet now. You understand? We want to know how to draft the document that we are going to use to prosecute him. We want to know how to draft the document containing the offenses, alleged to have been committed by Musa. So after we learn how to draft the document, then we'll talk about bringing Musa to court, or we'll look at if Musa is entitled to bail. You understand? But that will be a topic for another day. But then, for today, we start with charges. So, charges refers to the statement of offense with which a defendant is charged with in court. You understand? Charge is that document containing the offenses for which a defendant is charged with in court. If you look at the definition under ACJA and ACJA Lagos, you understand that the implication thereof is that in ACJA and ACJA Lagos, when they talk about charge, they're talking about either charge as used in the magistrate court or information as used in the high courts, you understand, the superior courts. But then when we talk about ACJL Kano, when we mention charge in ACJL Kano, charge is charge, you understand. Information is not used in the notes. Information is not used in the notes. So now we might ask ourselves, what is the essence of a charge? Why should we have a charge sheet? Why should we have a document called charge? You understand? Now the essence of a charge is for the defendant to know the offense against him. You understand? For him to know the allegations of crimes against him. Because ordinarily in court, the registrar will usually read it out. Car for corn. That's you on the dash day of dash 2024, around the 11 a.m., around so place, you did this, you did that, and then they will ask him, whether he pleads guilty or not guilty. So a defendant ordinarily cannot plead guilty unless there's a charge sheet in front of him. You understand? So he has to have the charge sheet read to him before he can know if he wants to plead guilty or not guilty. In order for him to know if he wants to plead guilty or not guilty. So now we might ask ourselves, what is an information? From the beginning I said an information is a type of charge. You understand? An information is a type of charge, just that is more comprehensive. You understand? Charge is a general name, but then sometimes we'll distinguish and say in the north what they draft is charge, while in the south what they draft in the high courts is information, why in the magistrate court in the south what they draft is charge. But charge is just a general name. It's a document itself. We call it charge sheet. You understand? It's a document itself. We call it charge sheet. But information now is a type of charge. You understand? As we're going through this work, we'll see samples of charge sheets and samples of information, how they look. Understand? So information is a type of charge. The only difference is that it's more comprehensive. For instance, in an information, you see stuff like statement of offense, particulars of offense, and all the rest. And then information in the broadest sense or in the broadest perspective will contain a lot of things as well. Understand? It will contain things like proof of evidence, that is like statement of the witnesses, the statement of offense itself, the person is alleged to have committed, list of witnesses to call, list of exhibit to tender, and all those things. Although we'll just concern ourselves with the statement of offense. So an information is broader, you understand? It's more comprehensive than the charge, than a mere charge. It's more comprehensive than a charge. But have at the back of your mind that an information is just a type of charge. For instance, in exam scenario, they will give you a very long scenario, and then they will tell you the Attorney General has authorized you, the State Council, to draft the charge. You understand? So the implication is that they assume, but if you look at the scenario, you know that what you are going to draft is an information. You understand? You're not going to draft a charge like you're charging the person in a magistrate court unless you are in the north. You understand? It's in the north that both in the high court and both in the magistrate court, they use a charge, not information. But what I'm trying to say is that in an exam scenario, they will never tell you to draft the information. They will use the general name charge. And then it's from the scenario that you will now look at, oh, this thing occurred in the south. You understand? And then the high court, the state high court has jurisdiction. That means what I have to draft is an information, not a normal charge. So nobody's going to call it information for you. Even if you're required to draft information, they will call it the general name. And the general name is charge. So who are the prosecutorial authorities? Now, prosecutorial authorities are the authority that prosecutes an offender. Who prosecutes an offender? You understand? The person that will prosecute an offender depends on the nature of the offense, for instance. So it could be a state when an offender has infringed the law of the state, then the state will prosecute you. It could be commissioner for police, you understand? Commissioner for police prosecutes offense in magistrate courts, you understand? When the magistrate court has jurisdiction to try a case, it is usually the commissioner for police that that prosecutes the offense in the name of the commissioner of police that prosecute the offense. And then the inspector general of police can also prosecute an offense, depending on the nature of the offense. For instance, in the FCT, when a person commits a federal offense, an offense that is of a federal nature in the FCT, and then the magistrate court has jurisdiction over such an offense, it is the IGP. It will no longer be the commissioner for police. It will now be the IGP that will prosecute the offense. Example of such offense, I know some people might be wondering, are there federal offenses that magistrate courts can try? Of course, there are some federal offenses that are not really of a very significant or very weighty nature. For instance, all this pipeline vandalism is a federal offense, and the magistrate court has jurisdiction to try such offense. So in that case, it will no longer be the commissioner for police; it will now be the IGP, because such an offense is a federal offense, and the magistrate court has jurisdiction to try them. And then we have the Federal Republic of Nigeria. Now, anywhere anybody is in Nigeria, whether in Abia State, in Calabar, in Kaduna, if you commit a federal offense, for instance, such as being in possession of hard drugs, the prosecutorial authority is going to be the Federal Republic of Nigeria, you understand, because the offense is an infraction against the Federal Republic of Nigeria. And then we talk about drafting authorities. Now, drafting authorities refers to people who draft the charge, you understand? Who draft a charge sheet, you understand? So the Attorney General of the state or of the federation is one of the drafting authority, but he does not do it himself. He usually delegates state councils. That is why if you go through past questions in charges, you will see something like the Attorney General has delegated you a state council to draft the charge, you understand? So the Attorney General is a drafting authority. And then he can delegate the state council to draft the charge. And then another drafting authority are police officers or law officers, understand? Police officers draft charges in the magistrate court south, you understand? The magistrate court south, it is police officers that draft charges. And then the magistrate can also draft charges, and that is what we have in the north, you understand? So in the north, it is the magistrates that draft charges in the north. It is the magistrate that draft charges in the north at the magistrate level, you understand? Like this, if a case comes up before the magistrate court in the north, it is the magistrate himself that is going to draft the charge. But if a case comes up in the south that is within the jurisdiction of the magistrate court, it is the police officer that will draft the charge. But whether in the north or in the south, if a case is within the jurisdiction of the state high court, it is now the Attorney General of the state that will draft the charge, and he usually delegates it to maybe any state council or any principal council. And then when the offense in question is a federal offense, the Attorney General of Federation will be the person that will draft the charge. And as usual, he will delegate the drafting exercise to any council in the Ministry of Justice. And then and then we look at the form of a charge. You understand? So how does a charge looks? Although we are still going to see the practical aspect, but it's relevant to know that as a matter of form, every charge must have a heading. You understand? Heading of the court. When you hear heading of the court, and we're talking about where you see in the High Court of Lagos State, in the Lagos Judicial Division, holding at Lagos. You understand? That is what we call heading. You understand? And then now this form, see, law school marks, they mark you based on form. Understand? Law school marks you like when it has to do with drafts. When it has to do with drafting, they mark you based on form. For instance, now only this heading in your draft, only this heading might give you like 1 mark or 2 marks. You understand? And then the next thing is charge number. Charge number may have like half mark or 1 mark. And then another thing is the parties at the left hand side. You understand? When parties now you have to put, for instance, the state, or if the offense was committed within Lagos, you say the state of Lagos. You understand? And then you do your dash 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 complainant, and you do the same thing for the defendant. Okafokon dash 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 defendant. Now only that one can give you 1 mark. You understand? So that is how they mark at the Nigerian law school. Everything is apportioned the mark. You understand? Everything is apportioned the mark. It's procedural. Understand? So they won't just look at it and mark you cumulatively. Most times in university they do cumulative marking. They look at everything you write and then they weigh it in an imaginary scale, how much sense you made, and then they give you your marks. You understand? But at the Nigerian law school, everything is procedural. They start from your heading, they mark you the charge number, the parties, then you just like that until your signature at the last part. You understand? So everything is procedural. So you don't have to miss anything. You understand? So as much as just write that. Just write that. So when we talk about content of a charge, now I will give you an acronym. So this is going to guide you. You understand? It's going to guide you. Content of a charge. Most times in exam, what people draft is information. You understand? What people draft most time is information. So you can go with this acronym, ND TAJOV. You understand? ND TAJOV is a proper acronym or mnemonics that will guide you. Now the first word there is N. That N stands for name of the offender. You understand? And then the D stands for the date and time of the D stands for the date of the commission of the offense. Now this is content of a charge. You understand? So any charge you're drafting must contain these items: the name of the offender, the date in which the offense was committed, the time in which the offense was committed. Unless from the scenario no time was given to you, then you move on. The address or the location in which the offense was committed. You understand? The judicial division within which the offense was committed, the specific offense, the offense in question that was committed, and then the victim against whom the offense was committed. So if you join all these together, you'll get ND TAJOV. You understand? So even if you don't know any acronym, even if you don't want to memorize, you don't want to hold or get any mnemonics, don't forget this one. Understand? Don't forget this one. If you're in Lagos campus, you might also get this acronym from Professor Nasiru Tijani, DD Pops, but for me, it doesn't rhyme very well. You understand? So I prefer this one, ND TAJOV. You understand? Because it's word for word. N stands for name, D stands for date, T stands for time, A stands for address, but you can say address or location. J stands for judicial division, O stands for offense committed, V stands for the victim against whom the offense was committed. So that is ND TAJOV. You understand? ND TAJOV. So now let's properly analyze the content of a charge. So every charge must have the name of the offender. You understand? That is the person who committed the offense. If the person has a nickname, you add the nickname. Every charge must also contain the date in which the offense was committed. You understand? It must also contain the date in which the offense was committed. For instance, on the 25th day of August 2024, that kind of stuff. But don't use on or about. You understand? Those things are now a cake. You understand? Those pattern of drafting has gone into a state of antiquity. You no longer use on or about. If from the scenario given to you, no date was provided, you can just use ellipses, dot, or just say dash. You understand? Don't use on or about. Don't use the word on or about the 25th of August. No, just say on the dash day of dash is okay. But from the scenario, definitely you will get a date. And then another thing is the time in which the offense was committed. If a time was provided in the scenario, use the time in which was provided in the scenario. And another one is the address or the location, or you can say the place in which the offense was committed. Now, this includes the exact location, the local government area, if you know it or if it's provided in the scenario, and the judicial division or the magisterial district within which the offense was committed should be stated. Understand? So when we say judicial division, we are talking about for state high courts. State high courts are divided into high courts. High courts are divided into divisions. Understand? Divisions. Or we can say superior courts are divided into divisions. Why for magistrate courts, they are divided into magisterial districts. You understand? Magisterial districts. But most times in exam, what they give you is an offense for which the high court can try. You understand? So just have in mind judicial division. And then every charge must contain, the charge or the count. That is the offense in question in which the person committed. And then the person or the victim against whom the offense was committed. And then every charge or information must also contain the punishment section contravened. You understand? Now we're talking about generally. This is more like a general overview. Now every information or charge must contain the punishment section contravened. Understand? It's important to contain the punishment section contravened, because remember, section 36 sub 2. Section 36 sub 12 is of the effect that a person cannot be tried and convicted for an offense. For an offense that is not prescribed and this penalty contained in a written law. You understand? So every offense for which you are charging a person must be defined in a written law, and this penalty must be prescribed in that written law. So you cannot be charging a person and then you are not stating the punishment section that provides for such an offense. And then I want you to know that you don't charge a person under a definition section. For instance, if you look at our laws, let me say, for instance, 357 sub 1 might define the offense of rape. And then maybe 370, or let me say 364. I'm just giving an instance. For instance, you might see 357 criminal code, we define rape, and then 360 we then provide the punishment for rape as maybe life imprisonment, or maybe 22 years imprisonment, as the case may be. So now, if you're charging a person for the offense of rape, you don't charge him under the definition section. You go to you are going to use the punishment section to charge the person. You understand? You are going to use the punishment section. So if you are saying and thereby committed an offense punishable under, you are supposed to use that section that provides for the punishment and not the definition section, because the essence of bringing a person to court is to face the consequences of his action. The consequences of his action or the punishment for his action is not provided in the definition section. That section that merely defines what is rape is just the definition section. So what you're supposed to use is a section that prescribes the penalty for rape. That is how it is done. So now we look at the sample draft of a charge in the magistrate court. If you look at the sample draft in the magistrate court here, you see in the magistrate court of the Federal Capital Territory, Abuja, in the Abuja Magisterial District, holding at Abuja. Understand? So this is how you couch your heading when it has to do with magistrate court. You first of all state the court it is, the magisterial district, and then where it is holding. Oftentimes, a matter will definitely hold in that division or that magisterial district in which it is brought. You state your charge number. Now, I just put this MC 977/24 for formality purposes. In exam, you can just put your charge number and put dash. You understand? The most important thing is that you stated charge number there. They just want to see that charge number. It shows that if you're drafting a charge, you know that the charge is supposed to have a charge number. And then between the Commissioner for Police, who is the complainant, and Musa Adio, who is the defendant. So now I want you to understand something. In drafting your charge in the notes, now in this case, if I'm talking about charge, I want you to know that I'm distinguishing charge from information. Understand? We are no longer talking about charge in the general sense. Now we are not talking about charge as used, for instance, charge in the magistrate court and then information in the high court as used in the south. Although in the north, charge is used both at the magistrate court and both at the high court. So I want you to know now that if you're drafting your charge, in the north, there are a lot of nuances in charge, but you just have to know them. With time, when you're reading it for the first time, it might be a little bit confusing, but with time, you're going to get acclimatized with it. So if you are drafting your charge in the north and is a magistrate court, charge in the north in the magistrate court has what we call three paragraph drafting. You understand? So the first paragraph introduces the magistrate. You understand? Introduces the magistrate. That is the presiding officer of the court who is charging you. Remember, he's the one that drafted the charge. You understand? So technically, he's the one charging you. You understand? You understand? So the first paragraph, charge in the magistrate court north, is a paragraph that introduces the magistrate in charge of that court. You understand? So you hear something like, I, Jimo Aziz of Chief Magistrate Grade 1, charge you, Musa Adio, as follows. Understand? So he has introduced himself. And then the second paragraph now contains the offense. For which you committed. That is, it contains the count or the charge. Charge 1, count 1, depending. You understand? So the second paragraph now will now be the offense you commit. Like, it contains the charge or the count. You understand? So here you see something like, that's you, Musa Adio, on the 25th of July 2024 around 11 a.m. at Buhari, Kogo local government within the Buhari Magistrate District, unlawfully inflicted injury on one Mr. Konbasi and thereby committed the offense of assault, punishable under the Penal Code Act. Now, this is just a class exercise. You understand? That was why I said under the Penal Code Act. But in exam scenario, they will provide you with this Penal Code Act, and you are going to see they will provide the definition section for you. They will provide the punishment section for you. You understand? So you will be the one to take the punishment section. If it is exam scenario now, maybe the punishment section for this offense of inflicting injury of Mr. Kombasi, if the punishment section is 351, I'm going to say committed the offense of assault, punishable under section 351 of the Penal Code Act. I won't just say Penal Code Act. You understand? This draft was actually drafted during a class exercise. You get? So, and then we have the last paragraph. Now, the last paragraph is the direction paragraph. Now, the magistrate is going to direct that you be tried on the said charge. You understand? So, the first paragraph, he introduces himself. The second paragraph contains the count or the charge, containing all relevant particulars of you, that is containing that ND Tajov. Then the last paragraph is the direction paragraph, where he's directing that you be tried by this court on the said charge. And then what do? You date your charge. You date your charge. Oftentimes you use the date of that particular day you're writing your exam. You date your charge, and then at the right hand side, the magistrate will have to sign. You understand? So in an exam scenario, you are assumed to be the magistrate. So you'll be the one who will sign at the right hand side. You understand? So you can see the signature here, and his name, Aziz Jimo, Chief Magistrate Grade 1. You understand? So now I want you to understand something. In charges, there are a lot of nuances. You understand? It might look difficult at the first time, but with time, you understand? Charge is one of the things I encourage students. If you have not had an idea, although I already knew charge before I came to the university, because in my school, Nnamdi Azikiwe University, in final year, we do a course called advocacy. Advocacy is a combination of civil litigation and criminal litigation. You understand? Although we don't go deep, we usually do not go deep, but we did charges. You understand? So I really did not find all these nuances difficult. But if you're in a school where you didn't do anything like that, or maybe you don't have an idea about charge, you understand? Just calm down. You understand? Charge is something that I encourage students that every Saturday pick up your pen and draft. And what I would advise you to be drafting is information. You understand? This is magistrate court notes. They know in the past 10 years, nobody has asked students in exam to draft a charge sheet in the magistrate court note. It's almost impossible, but know it for knowing sake. Because in Nigerian law school it's funny, you don't know where they will come from. So know it for knowing sake. But every weekend, you can take out every Saturday, every Sunday to just practice your charge sheet. Just practice it, you understand? Immediately it is taught. Immediately it is taught in class as a topic for that week. From that week until you master it, just keep practicing your charge, you understand? That is one way you're going to master it very well, and it has a lot of nuances. For instance, now this is the High Court, this is the Magistrate Court of the Federal Capital Territory, and that was why we used Count 1. But other magistrate courts in the north, we are going to use Charge 1. Other magistrate courts in the north, we won't use Count 1, we use Charge 1. You understand? So this was how it was explained by Professor Nasir Tijani. So we are using Count 1 because is the magistrate court of the FCT. But if it is the magistrate court in other states in the north, we are going to use Charge 1. You understand? We're going to use Charge 1. So now we have seen how a sample of a charge looks in the magistrate court in the north. Now let us look at how a charge looks in the magistrate court south. You will notice the difference. In the magistrate court south, there is nothing like first paragraph where the magistrate introduces himself, or the third paragraph where he gives the direction. No. In the magistrate court south, there's nothing like that. You understand? Because it's not the magistrate that is drafting the charge. In the magistrate court south, it is the police officer that drafts the charge. So if you look at it here, it's very simple. There's nothing like I, Jima Aziz of Chief Magistrate Grade 1, or I direct that you be tried. No, there's nothing like that. You just put your head in, charge number, parties, Count 1, you date it, sign, and then the police officer will have to sign and put his name and all. And then, this is just an example draft. You understand? Nobody can give you a draft in exam where you have only one count. You get? So this is just an example draft. In an exam scenario, you will have up to 7 counts or 8 counts. You understand? So where there are up to 7 counts or 8 counts, is still the same procedure is going to be. Count 1, he carted away, that is stealing. Count 2 might be maybe he inflicted injury on someone. Count 3 might be he was fighting in public, afraid, just like that. So when you write all your counts, you put your date, put your signature, and and then the name of the police officer and all. And then again, I want to make another point. Like I said before, charges has a lot of nuances. I said something before. Magistrate courts north. All the magistrate courts in the north, apart from the FCT, what we use is Charge 1, Charge 2, Charge 3. We don't say Count 1, Count 2, Count 3. You understand? It is only the FCT that we say Count 1, Count 2, Count 3. And then when we get to the Federal High Court as well, you know that if you're charging someone in the Federal High Court uses charge. They don't use information. They use charge. But then inside of that, their charge, you will say Count 1, Count 2, Count 3. You won't say Charge 1, Charge 2, Charge 3. So the Federal High Court uses the same format as that of the FCT, when it has to do with charge. Or then magistrate court in the south, where police officers draft it, what we use is Count 1, Count 2, Count 3. The same as High Court South, where we use Count 1, Count 2, Count 3. So don't worry, these things will be they'll be moving here and there, springing up and down like billions of neurons in your brain, but you are going to capture it. And then one advice I would give you is that even if you won't know any other, even if you might be confused on how you might go about your charge, but just know how to draft your information. We'll get to that later. Just know how to draft your information, because that is 90% what you see in your exam. That is definitely what you see in your exam. Nobody will disturb you about drafting a charge. A charge, I mean, as in magistrate court, it will definitely be in the High Court, and most times they will take it to the south so that you will draft an information and not the normal charge. So now, in the High Court of Kano State, now we have gone to high court. Now we are no longer in magistrate courts. We are now in high courts. So I believe you understand the no one sees in the high court, in the magistrate court south, magistrate court north. You understand? In the magistrate court north, you have the 3-paragraph drafting, and it is the magistrate that is drafting the charge. You understand? But then in the magistrate court south, there's no 3-paragraph drafting. What we have there is just the heading, the party, and then the count. You understand? We just go straight to the point, the count. So now we go to the high court. You understand? We go to the high court, and then we start from the high court north. So now, if you look at the high court north, you will see that what they use in the high court north is still the normal charge. You understand? The normal charge that is applicable in the magistrate court is the same thing that they use in the high courts in the north. You understand? Unlike the south, where once you get to the high courts, they are now using information. It is not like that in the north. So in the north, they still use charge. You understand? But what you have to understand is that here now, there is also no longer 3-paragraph drafting. You understand? So in the high court north, they still use charge. But here, they don't go with the 3-paragraph pattern where you have the magistrate introducing himself and then directing that the person should be charged. You understand? You know, in the high court, and one of the reason why you don't see the 3-paragraph drafting pattern here in the high court notes is because it's not the magistrate now that is drafting the charge. You understand? So he you know, there's no need to introduce himself, and then there's no need to direct the person that is drafting the charge here now. Since it's, for instance, is the High Court of Kano State, the person that will be drafting the charge here now is the Attorney General of Kano State. You understand? So you will notice that High Court, you notice that the High Court in the North, you know, their charge is similar to the Magistrate Court in the South. You understand? So you will notice that they are a bit similar. You get, so don't get confused. You understand? So this is how it is done in the high court in the north. You know, the heading of the court, the charge number, the parties, and then charge one. You understand? They don't say count one. They say charge one. They say charge one, and then you state everything complete, and then you date it, you sign it, and then you see. Now the state counsel, Clement Okafor Esquire, is the principal state counsel, and then he's signing on behalf of the Attorney General of Kano State. So you can see a scenario where they say you have been required to draft the charge. You understand? You have been required to draft the charge on behalf of the Attorney General. So this is how you do it. You know, you date it, you sign it, you put your name, put your designation, principal state counsel or senior state counsel, and then for the Attorney General of Kano State. You understand? But now we'll get to the main draft. This is what you see every time in your exam. You understand? So even if you might be confused with other patterns of draft, even if don't be confused for information. High Court South, information. High Court South, information. You understand? Nobody's going to ask in the exam to draft for magistrate courts. In the past 10 years, there have never been any question like that students should draft a charge in the magistrate court. It's not possible. You understand? So what you should have in mind, like, even if you won't know how to draft anything, know how to draft an information. So we have been saying that an information is a type of charge. An information is a type of charge, but it's more comprehensive, it's more detailed, An information is used in the High Court South. And then at the same time, the High Court of the FCT uses information. The FCT is considered to be a northern state. In a way, it's considered to be a northern, like in Nigeria, in a way, we consider the FCT to be, not like it's a northern state, but like it's northern, The FCT is not in Lagos, it's not in Port Harcourt, it's in the north. Even if it's like an independent entity, but in a way, not independent actually, even if it's like an entity on its own, but we still consider it northern. You understand? So in this case, the FCT High Court is taking an exception. Now it's saying we are not going to use charge here, we are going to use information. You get? So you have to bear this in your mind. The nuances are a lot, you understand, but you just have to know them. Try your possible best to know them at your fingertips. So High Court South is information. High Court FCT is information. You understand? Federal High Court is charge. You see these three. If you know these three, you're okay. You don't need to bother yourself about magistrate courts, wherever they are. Nobody will ask you to draft for magistrate court. Just know these three. High Court South information. High Court FCT information. Federal High Court charge. High Court North charge. You understand? And then High Court North, there's no 3-paragraph drafting. It's just the normal charge that you know. So now we look at how an information looks. And then we are using South, for instance. And then the South we are using is Lagos State. Now, Lagos State also has its own nuances that you have to also know about. You understand? So now, you see, here we have the heading in the High Court of Lagos State, in the Lagos Judicial Division, holding at Lagos. Now, as well, the scenario can be at Ikeja. You understand? Ikeja is a judicial division. If from the scenario it happened in Ikeja, you will now say in the Ikeja Judicial Division, holding at Ikeja. Understand? So it is the scenario that is going to let you know what judicial division that is playing, that the scenario is happening. You put your charge number and then parties between. Now we call it the state of Lagos. We no longer say the state. You know, when we are drafting our charge and whatever, for other states, every other state in Nigeria, they will just say the state. Understand? If it's Bayelsa, if it's Kaduna, if it's Kano, if it's Ondo, Adamawa, Rivers, they will just say the state as the complainant against the defendant. You get? But now Lagos said, no, don't call us the state. Call us the state of Lagos. So have that in mind. Apart from that as well, Lagos also have another nuance. You understand? Every other state, what they usually have is criminal code law. But Lagos said, no, what we have is criminal law. You understand? So if, for instance, you are drafting your charge, you will not say punishable under section 42 of the criminal code law of Lagos. You will say criminal law of Lagos. You understand? That is what you are going to say. Criminal law of Lagos. You won't say criminal code law of Lagos. You won't say the state. You will say the state of Lagos. You know, that is just Lagos and their wahala, but it's something you should just know. You understand? Just try and have it at your fingertips. So this is what an information looks like. We have the heading, the charge number, the parties, and then this first paragraph is what we call the preamble. Understand? The preamble is what we call the preamble. Now the preamble looks this way. At the session of the court holding at Lagos on the dash day of dash 2024, the court is informed by the Attorney General of Lagos State on behalf of the state that you now list the name of the defendants again. Musa Adio, Morgan Demba are charged with the following offense. Now, in the alternative, you can say at the session of the High Court of Lagos State, holding at Lagos on the dash day of dash 2024. You understand? You can say at the session of the High Court of Lagos State instead of saying at the session of the court. You can say at the session of the High Court of Lagos State. It's still correct. And then you can say instead of saying are charged with the following offenses, you can say are charged as fellows. It's still the same thing. That is just a matter of nomenclature. Understand? It's still the same thing. But now you see we listed Musa Adio number 1, Morgan Demba number 2. Now, if it's just one person, you don't need to list it. You will just say on behalf of the state that Musa Adio is charged with the following offenses. If it's just one person, no need to list it. Just state it like it's a sentence. You understand? But if there are more than one, you have to list them. And then the next thing you have is a statement of offense. That is where you have your count. Count one, statement of offense. Now, if you look at how information is, you see that it's detailed. And information is detailed, and information is compartmentalized. You understand? It's not jumbled together. If you look at how a normal charge is in the magistrate court and in the high court notes, you will see that it's jumbled together. Everything is jumbled together. The statement of the offense and the particulars are jumbled together. But now, for information, they are separated. It's neat. You understand? It's neater. It's detailed as well, and it's compartmentalized. You understand? So we have the preamble. Then now we have the statement of offense. Count 1 on top. Then statement of offense. Stealing, contrary to the criminal law of Lagos State. Understand? Stealing contrary to the criminal law of Lagos State. Now, remember what I told you about punishment section. You don't charge a person under a definition section. You charge a person under the punishment section. You understand? So if, for instance, this is an exam scenario now what I'm going to write here now is stealing contrary to, let me say, section 47, criminal law of Lagos State. Maybe section 47 provides for the punishment section of stealing and makes it maybe punishable with 3 years imprisonment. I will say contrary to section 47 of the criminal law of Lagos State. You understand? That is what I'm going to say. I won't charge the person under the definition section. And then the next thing is the particulars of the offense. Now, the particulars of the offense is where the ND tajob comes in. You understand? That is where the ND tajob, the mnemonics or the acronym, that is where it comes in. You understand? Now, like I told you before, even if you don't want to memorize anything, know how to draft your information. That is definitely what you draft in this thing. That is definitely what you draft in exam. Understand? Charges is divided into two. We have charges as per form. Know your form. You understand? Like, for instance, everything we have been discussing here is based on form. We will get to the substance later. It is in the substance that you have to know when you go to another count. You know, when you move to another charge sheet. You know, all those things, the rules of drafting charges and all those ones. Those ones will still come, but know your form. Your form is very, very important. Know your form first. Understand? Know your form before you now talk about the substantive aspect of charge. You understand? So this is where that ND tajob comes in. You understand? Particulars of offense. The name of the person first. The date, the date in which the offense was committed. The time in which the offense was committed. The address or the location in which the offense was committed. You understand? The judicial division in which the offense was committed. The specific offense itself committed, and then the victim, ND tajob, it rhymes, you understand? And then the victim against whom the offense was committed. You understand? The victim against whom the offense was committed. It rhymes. If you know this acronym, you are not failing anything related to form when it gets to particulars. And then these particulars are very, very important. There's a way the law school marks, there's this rule, we still get to it. The rule against ambiguity. If these particulars are not properly stated, if you take the victim and you put where you're supposed to put address, the victim of the offense cannot come before the address. The time of the offense cannot come before the name of the offender. You cannot say for instance, you cannot start your particulars and say around 10 a.m. No. That is now ambiguous. You understand? You are arranging them improperly. You understand? So these are the things they mark. So even if you don't know any acronym, know this acronym. ND tajob. It is well arranged. Use it like that in the exam, and it's going to be okay. So now we have the particulars, and then one thing you notice here too is that in information we don't say that we have taken that one aside. We no longer say that. That one is used in magistrate. That's you, Musa Adio, on the 25th of August around 9 a.m. No. In information now, you just call the person's name. Understand? No need to say that you. We don't do that. Understand? So, Musa Adio and Morgan Demba on the 25th day of July 2024 around 11 a.m. at number 139 Crescent Street, Lagos State, within the Lagos Judicial Division. Carted away a television set belonging to one Mr. Konbasi with intention to permanently deprive him of the tin of it. You understand? So this is a classic example of how particulars of offense look. You understand? This is how it looks. And then if you notice very well, you see that in the particulars of the offense, we did not use the exact word. When I say the exact word, this person committed the offense of stealing. We have already stated stealing at the statement of offense. So you will not come back again and use stealing in the particulars. But I don't really know whether it's of any consequence, if they will deduct your mark, or maybe it's permissible. You understand? I don't really know. But I know that when we were taught in class, we were not allowed to use the same word we used in the statements to reflect it again at the particulars. You look for something else. And then one way to look for something else, that you look at the definition section. In your exam, for instance, your statement of offense should be tied to the punishment section. But then your particulars, when you want to couch that particular thing that person did, when you look to the definition section, you see a guide. You understand? You see a guide. For instance, now, if this is an offense of rape, now the statement of offense can say rape contrary to. Then the particulars now will be Musa Adio and Morgan Demba on the 25th of July 2024 around 11 a.m. at number 139 Crescent Street, Lagos State, within the Lagos Judicial Division, had unlawful carnal knowledge. You understand? Because that is what the definition section is going to define rape as: unlawful carnal knowledge without the consent of the person. You understand? So that is what I'm saying. For your particulars, when you want to state what that person did, the definition section will usually give you a hint, a guide, on how to describe the offense. You understand? Because you are trying to describe the offense a person committed. So that is how you do it. And then after that, you date it, you sign, and then you put, Clement Okafor Esquire, Principal State Counsel for the Attorney General of Lagos State. That is it. So, like I told you before, the High Court of the FCT uses information as well. So now we're in the High Court of the FCT. You see that it is essentially the same. Information is information everywhere. High Court of the FCT uses information. The only difference or distinction you'll be seeing here is that, for instance, in terms of the heading, in the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division, holding at Abuja. You understand? Charge number, and then now the prosecutorial authority is now the Federal Republic of Nigeria. You understand? No longer the state of Lagos. Anything that is happening in the FCT is Federal Republic of Nigeria. You cannot come here now to write Federal Capital Territory. You will be in book soup. Understand? You can't come here to write the state of Abuja. That's legally impossible. You understand? So is anything happening in Abuja is the Federal Republic of Nigeria. So the preamble is also the same. You can say at the session of the court, you can say at the session of the High Court of the Federal Capital Territory, holding at Abuja on the dash of dash. This court is informed. Now it is no longer the Attorney General of Lagos State. It is now the Attorney General of the Federation on behalf of the Federal Republic of Nigeria. Understand? I think that day in class, some persons were asking Professor Nasiri Tijani if they should say on behalf of the Federation, on behalf of the federal government. And he said no. He said use on behalf of the Federal Republic of Nigeria. Understand? That is more fitting and more appropriate. So the same thing, statement of offense, particulars of offense, and then in the FCT, I hope you know the applicable criminal, the applicable penal or criminal law is the Penal Code Act. Understand? Is the Penal Code Act. The Penal Code Act is the applicable law in the FCT. So the same thing. And then we go to the Federal High Court. Now, the Federal High Court does not use information. The Federal High Court uses charge, a mere charge. The Federal High Court uses normal charge. So it's similar to what we have in the High Court North. The Federal High Court anywhere in Nigeria uses charge to prosecute offenders. And it's similar to what we have in the High Court North. So now you might see a scenario where it occurred in Lagos. You understand? But then if the court has jurisdiction to try that matter, you won't gonna be drafting information. What you need to draft is a charge, since the Federal High Court has jurisdiction to try the matter. We have only one Federal High Court in Nigeria, and that is the Federal High Court of Nigeria. And then the Federal High Courts are only duplicated across states, for administrative convenience. So the Federal High Courts in the Lagos Judicial Division, for instance, and the Federal High Court sitting in Kano, Federal High Court sitting at Abuja, Federal High Court sitting in Port Harcourt are all the same. It is the same Federal High Court of Nigeria. So the law is that Federal High Court uses charge. So whether it is in the south, it is in the north, it is in the FCT, wherever, if the offense is triable at the Federal High Court, it is by way of charge, not information. But then in the charge, what you say is count one. You don't say charge one. You say count one. Just like a magistrate court in the FCT, we say count one as well. And then you might ask yourself, how do we now go to other issues, like how do we couch the party's designation? If, for instance, now in an exam scenario, they arrested only one person, while three others are now at large, like they escaped. So how do we now catch the parties? How do we catch the parties? You understand? I just added this one for clarity's sake. It's not in any textbook. Yes, I just added it for the sake of clarity for people reading the work. Understand? So you can see how it's couched here. Okafor Cone and others for the party's designation. Then when you go to the particulars, you say something like Okafor Cone and others now at large. Now at large signifies the fact that maybe two other persons or three other persons are now at large, like they escaped. You understand? But if, for instance, those other persons that escaped are designated, like in terms of their number. You understand? If, for instance, from the scenario they said four persons escaped, now you will now see Okafor Cone and four others now at large. You understand? That is how you couch it. And then one thing you must have to note as well is to distinguish. You have to be able to distinguish. The offense of stealing from the offense of robbery and armed robbery. If you go through the past questions in charges, you will notice that there's something very tricky that the examiners do. You understand? The examiners will provide a punishment section for stealing. They will provide a punishment section for robbery and provide a punishment section for armed robbery. You understand? And then if you're not careful, you might go and drop nonsense. That is now we're talking about the substance of charges. We are no more doing form. We are done with form. Now we're in substance. You understand? We're in substance. So if you're not careful enough, you might be charging someone for stealing when he in fact committed armed robbery, or you might be charging someone for armed robbery when he in fact committed stealing. You understand? So you need to distinguish. You need to know the difference. This is something you must have known from your university, or if you have forgotten or you were not properly explained to the distinction, then we have to refresh your memory. Now, when we talk about the offense of stealing is simply taking. You understand? The one major element of stealing is that you must move that in. You must have taken that in, and the victim doesn't even he doesn't even need to be around. The victim need not be present in offense of stealing. The victim need not be present, and then an offender in the offense of stealing is not armed. You understand? He just goes to take the thing to permanently deprive the owner of that thing. That is his major mens rea. That's the encapsulation of his mens rea. He moves or takes something to deprive the owner of that thing permanently. The victim need not be present, and the offender is usually not armed. And what is robbery? Now, robbery is stealing coupled with violence or the threat of violence. You understand? Robbery is stealing plus violence or the threat of violence. So if you're present in a place and then somebody collects your watch and then you try to fight back and he punched you with his fist, he punched you, or he gave you uppercut and then collected your watch. You understand? That is robbery, because there is violence or the threat of violence. Or maybe he said, if you don't give me that watch now, I'm going to punch your face. Understand? And then maybe he's very muscular, bigger than you. That is robbery. But now, whenever a person is doing robbery, whenever a person is committing the offense of robbery and he's armed, he's most times or usually or more often is a gun. You understand? The person is holding a gun. Now, what the person is doing has metamorphosed into armed robbery. It is no longer robbery. You understand? What he was doing before was punishable with, I think, 21 years imprisonment, but immediately he became armed, it metamorphosed to a death penalty. You understand? So immediately while a person is committing robbery, he shows you that he's in possession of an arm. It could be a gun, it could be a knife, it could be a machete, it could be a broken bottle, it could be even scissors. You understand? Provided that thing is capable of causing harm to you, it doesn't need to be something very big. You understand? Plank, bottle, sticks, whatever, you understand. Provided he's armed and that thing can cause you injury, it is now armed robbery. You understand? It is not armed robbery. So in an exam scenario, somebody can hold a gun and then he enters a place. He's like, "Hey, give me that watch." The person gives him the watch and he goes. There's no violence, clean robbery. He's holding a gun and the victim sees the gun and he's like, "Hey, give me that watch." The victim pulls the watch and gives him the watch. No violence. You understand? In this case, provided he's armed and the victim saw that arm, it is armed robbery. Understand? He didn't steal from the victim. It's not robbery. It is armed robbery. So at any point in time, whenever a person is armed and then he robs another, it has turned to armed robbery. It has turned to armed robbery. It has turned to armed robbery. So we need to know the distinction very well. You understand? So like I said, in an exam scenario, most times they will provide the punishment section for stealing, for robbery, for armed robbery, provided the person, you understand, provided the person took the property of the other person while he was armed. You understand? While he was armed, to the knowledge of the victim, it is now armed robbery. You understand? It is now armed robbery. It is now armed robbery. So now we go to the rules of drafting charges. We have looked at the form in which charges may be drafted. Now we are coming to the substantive aspect. Now you don't just come now and say, "Oh, I want to start drafting charges. 3 people committed several offenses. I want to start drafting charges." There are certain rules that you must obey. Understand? There are certain rules that you must obey, and when you don't obey those rules, there are consequences. You understand? There are consequences, and the consequences might be fatal. The consequences might be insignificant. The consequences might be menial. Understand? So it depends. So now we look at the rules of drafting charges, and I want you to understand that these rules of drafting charges are obeyed more in exceptions than the general rule. In other words, in the course of drafting your charges, you will see that you are more or less applying the exceptions more than the general rule. You understand? That is how charges are. Understand? So we look at rule number 1. Now, rule number 1 is a rule against ambiguity. I told you something about when you hear ambiguity, what should come to your mind is those particulars. End it a job. What should come to your mind is those particulars. I was telling you that you cannot carry address or location and put before the name of the offender. And then imagine when you meet one of them, you meet like 2 or 3. You don't put the name of the victim, you don't put the judicial division the offense was committed, you did not put the name of the offense. Like imagine where you omit any of those relevant particulars. Now, whenever you do that, that charge or that count is now suffering from ambiguity. It has offended the rule against ambiguity. You understand? It has offended the rule against ambiguity. So by the rule against ambiguity, now this rule simply states that when a defendant or an offender looks at a charge, that charge should be proper. By virtue of this rule, the rule against ambiguity, it is to the effect that when a defendant sees a charge against him, when you give him the document to read, he should immediately know the offenses. He should immediately know why he is brought to court. You understand? He should not read the charge sheet to which he's brought to court to, and then he's confused as to why he's here. You understand? So your drafting, if you're a state counsel, the charge that you drafted, the counts, everything must be properly drafted in such a way that once the defendant sees it, he already knows why he's in court. You understand? That is the fundamental pillar of this rule. That's the fundamental pillar of this rule. So now, what does it mean to say that a charge is bad for ambiguity? At what point can we say that a charge is bad for ambiguity? The answer is simple. Whenever those particulars end it a job, whenever those particulars end it a job, the name of the person, the date, the time, the address, the address, the victim, the offense committed, the victim. Now, whenever these particulars are improperly stated, improperly arranged, omitted. Some of the particulars are omitted. Now, whenever any of these things happen, maybe the particulars are stated in a disorderly manner, we refer to those things as particulars. The end it a job, we refer to them as particulars. So whenever they are arranged improperly in a disorderly manner, or some of them are omitted in such a way that the error, when they are omitted or when they are stated improperly, it is an error. That is an erroneous drafting. So whenever they are stated improperly in a disorderly manner, or some of them are omitted in such a way that the error is fundamental as to misdirect the accused, that is the defendant, and at the end of the whole day occasion miscarriage of justice, then we can say that that charge is barred for ambiguity. That charge you drafted as a state counsel is barred for ambiguity. You understand? Is barred for ambiguity. So now you might ask yourself, what is the effect of ambiguity? What is the effect of ambiguity in a charge? Or what is the effect of an ambiguity in a count inside of the charge sheet, for instance? Now, whenever you see questions like this, the effect of ambiguity, the effect of duplicity, the effect of any rules of drafting charges whenever it is breached, the effect is not absolute. The effect is contingent. That is, it's conditional. It's conditional on the weight of the error. It's conditional on the weight of the error. For instance, in the Fashola against IGP, the defendant was charged for the offense of stealing, but the victim against whom the offense of stealing was committed against was omitted in the charge. And the court was like, it's not necessary. Even if the victim of the offense of stealing is not stated, the most important thing is that this young man here stole a particular thing on so day, on so time within the judicial division of this court, and this is what he stole. Whoever he stole it from is immaterial. Understand? So it depends on the materiality. It depends on the weight, the gravity of maybe the particulars that was omitted or the particulars that was improperly stated. Was that error? Was it so material? Was it so grave? Was it so significant that the accused, that is the defendant, was misdirected? He was confused. He was embarrassed by reading the charge, or when the charge was read to him, you don't even know what he was pleading to again, because what you drafted was so ambiguous that the defendant, he didn't even know when he said guilty, because he don't even understand your charge again. Understand? So in that case now, the effect of that ambiguity is fatal. You understand? And that charge will be set aside. It's fatal, you understand? But if it's not fatal, the court is going to allow it, you understand? So like I gave you the case of Fashola against IGP, where only the victim of the offense of stealing was not stated. The court said, no problem, let's continue trial. So now the next rule is the rule against duplicity. Now this rule is simple. In your count, we saw something like count 1, count 2, count this, count that. So now imagine we are drafting an information. And then at the statement of offense, imagine we are drafting an information, and then we have said count 1. Yeah, we have said count 1. And then in that your count 1, you're supposed to have only one offense. You're supposed to have one offense, not two offenses. You're supposed to have, like by the rule against duplicity, one offense for one count. You cannot put two offenses in one count. For instance, now you cannot say Musa Okafor and Kennedy Okafor murdered and raped. You cannot do that. You cannot say they murdered and raped Charity. It's not possible. You understand? You have to use count 1, they murdered Charity. Count 2, they raped Charity. You understand? That is how charges are drafted. So you have to know these rules tip by tip. You have to arrange it in your head. We are done with ambiguity. Ambiguity has to do with those particulars. Arrange them very well. Put this one before this one. Don't put the other one before the other one when it's not supposed to be so. Don't omit anyone. Whenever they're improperly arranged or some are omitted, that the defendant is now confused, he doesn't even know what he's pleading to, and it causes miscarriage of justice, that charge will be set aside. That is all for ambiguity. Now, duplicity is telling you that one offense for one count. It's very simple. Don't come to count 1 and put 3 offenses there. You don't lump offenses together. One count for one offense. One offense for one count. The same thing. Count one, the defendant committed murder. Go to count two and say he committed rape. You understand? So that is how these. That is how this particular rule works. And then another side of this rule, the flip side, for instance, the flip side of this rule is that for instance, if someone committed murder against two people, maybe a robber, one person went to rob a bank, and then police officers came, and then they were exchanging bullets to the robber, and then the robber succeeded in murdering two police officers. Like he shot at two police officers in the course of exchanging bullets, and two police officers died. You cannot come now and say count one, Musa Okafor murdered Inspector Okon and Inspector John. No, you don't do that. Count one, he murdered Inspector Okon. Count two, he murdered Inspector John. That is how we draft it. You understand? This is the essence of the rule against duplicity. One offense for one count. One offense for one count. You understand? One offense for one count. That is how it's done. That is how it's done. So a charge will be bad for duplicity. A charge is going to be bad for duplicity when that charge or when that particular count in the charge sheet discloses more than one offense, then that charge is bad for duplicity. But then there are exceptions. You understand? There are exceptions. Like I told you before, when it has to do with the rules of drafting charges, draftsmen obey the exceptions more than the general rule. You understand? Draftsmen obey the exceptions more than the general rule. So now, now we look at exceptions to the rule against duplicity. And then one of the exceptions now is allegation of general deficiency of money over a period of time committed against one person, or claims in criminal breach of trust. So now, imagine a situation whereby you are working as a cashier. You are working as a cashier for a bank, or let me say Musa is working as a cashier for a bank. Now, Musa comes today, being 14th day of August 2025, for instance. He comes today, he diverts 4 million. And then maybe 2 months later, Musa diverts another 3 million. 6 months later, Musa diverts another 3 million. And then at the end of the whole year, he then diverted another 10 million, making it whatever total of money that he diverted. Let me say the total of money, for instance, is 50 million that he diverted throughout the year. And then he diverted the money about 6 times. You cannot come in your chart sheet now against Musa. You will say count 1, stealing of 4 million on so day. Count 2, stealing of 7 million on so day. Count 3, stealing of 10 million on so day. Count 4. No. You don't do that. What you have to do now is to aggregate all. It has to do with money. You understand? The only thing you cannot aggregate is property. You cannot aggregate property. You understand? But you can aggregate money. To aggregate money means join all of them together. If Musa stole total of 50 million from the bank, even if you stole the money on, let me say, different occasions, up to like 5 months or whatever, just aggregate them. Count 1, stealing money worth 50 million. It's okay. You understand? Don't go and be saying count 1, he did this. Don't go and say count 1, he stole 5 million today. Count 2, he stole 7 million the next month. No, you don't do that. So that is the essence of this exception. You aggregate. You understand? But this exception has condition. It has to be money. You don't aggregate property. If Musa came today and through the back door, he arranged some boys and they stole like 50 bags of cement from the company, and then tomorrow he arranged the next day they stole plasma. You understand? They stole plasma, and then the third day he arranged again and they stole the car of one of the managers. You understand? You cannot aggregate them together. You charge them separately. You understand? You charge them separately. So you can only aggregate money, and that money must have been stolen from one person or from one institution or from one entity. You understand? That money must have been stolen from one entity. from one person before you aggregate, and it must be related to money. You cannot aggregate property, and you cannot aggregate money stolen from two different persons or two different institutions. You understand? So it has to be from one person that Musa stole the money from, or from one institution, or from one company. And then another exception to this rule is overt act in treason. Overt act in treason. At least overt act in treason. So if you're charging a person for treason, you must show at least two or more acts constituting manifestation of the intention to commit treason. Anybody who wants to commit treason must have the intention to commit treason. So apart from stating that the person is charged for treason, you must have to show at least two overt acts, that constitute the manifestation of that his intention to commit treason. If you remember the case of Omi Sade against the Queen, you remember his confessional statement that he was going for training, where they were singing, carrying weapons and all, but he did not know that the purpose of the training was to levy war against the Queen. Understand? He didn't know that the purpose of the training was to levy war against the Queen. So the fact that let's imagine that he was tried for treason. The fact that he was going for training, shows it's more like a manifestation of intention. So you can include that in the count, you understand? And it's not going to be considered to be duplicitous. It's not going to be considered to have breached the rule against duplicity. And then another exception is statutory forms. Now there are some legislations, there are some statutes that allow you, by form, to bring two offenses together. That allows you to bring two offenses together. For instance, if you look at the Criminal Procedural Act, form number 16, it provides that a person can be charged. It provides that a person can be charged together for stealing and burglary, or for stealing and housebreaking, depending on the time in which the person committed the offense. So under the CPA, for instance, it is allowed that you can charge a person for stealing and burglary at the same time. So this is more like a statutory exception provided in some laws. You can charge a person for stealing and burglary at the same time, or stealing and housebreaking at the same time. The difference between burglary and stealing is the time to which the offense was committed. So you can charge a person for stealing and at the same time charging for burglary and housebreaking, and put it in the same count. Count one, Kafokon, charged with stealing and burglary. You can do that. It's allowed because of the Criminal Procedural Act. And then there are offenses that are defined in the alternative. When we say the alternative, they will define the offense is either you committed it like this or you committed it like this. So if you're drafting your charge sheet in your count as well, you can also say the person is charged with this offense, that he committed either like this or he committed either like this. You understand? So if you look at section 406, for instance, of the Criminal Code, provides for two ways in which a person may demand with menace. You understand? It provides for two ways in which a person may demand with menace. Either you're demanding with menace like this, or you're demanding with menace like that. You understand? So if you're drafting the offense as well in your charge sheet, you can say you are charged with demanding with menace, either this way or either that way. And so that is what they mean by offenses defined in the alternative. And then when a person commits a similar or identical offenses in the course of the same transaction, you can bring it together under one count. You understand? When a person commits similar or identical offenses in the course of the same transaction. In the course, you see this word, in the course of the same transaction, is very important, but we'll see that later. Understand? So when a person in the course of the same transaction commits offenses that are similar or identical in nature, I think two offenses during my university days, I found out that they are very similar. Is the offense of cheating and the offense of stealing. Because most time in the case of cheating, you are getting money. Understand? And then at the same time, in the offense of stealing, you're also getting money. Even obtaining by false pretense as well. So it's even similar to the offense of stealing. So somebody might have committed these two offenses, obtaining by false pretense and cheating. You can charge it together. You understand? Because they are maybe he committed obtaining by false pretense. He also committed cheating. You can charge it together because they are of a similar nature. They are of a similar nature. And then you might ask yourself again now, what is the effect of duplicity? Now, the principle that applies in ambiguity also applies in duplicity. The effect of any rule of drafting charges that is breached will depend on the materiality, will depend on the weight, will depend on the gravity of the breach itself. You understand? So, for instance, if in the case of duplicity now, the way you drafted the charge is so it's so duplicitous. Maybe you lumped up to like 4 or 5 offenses in one count, and then the defendant is even confused as to which of them he committed, and then it end up causing miscarriage of justice. Then that charge is going to be set aside. But if the duplicity is just minor, you understand, the court can still allow trial to continue. And then Agaba listed some ways in which you can determine whether or not miscarriage of justice occurred. You can look that up. And then the next one is the rule against misjoinder of offenders. Now, by this rule is simply saying that where there are 3 persons that committed an offense, each of them should have a separate charge sheet. For instance, put Okafor, he should have his own charge sheet. Okoro should have his own charge sheet, and Musa should have his own charge sheet. You understand? Don't bring the 3 of them together and be charging them for offenses. They should have every man for himself. This person should have his own charge sheet. This person should have it. So that is the essence. That's the general rule in this the rule against misgender of offenders. But as usual, there are exceptions. So there are instances where 2 or more persons will be charged together in one charge sheet. You understand? So the exceptions include where 2 or more persons commit the same offense. You understand? If 2 or more persons murder the person at the same time, they rape the person or they assaulted the person, they are parties to the offense by virtue of Section 7 of the Criminal Code Act. So they should be charged together. No need to provide 2 different charge sheets for them. Then where 2 or more persons commit different offenses in the course of the same transaction, you understand, they are also parties to the offense. They should be charged together. So where, for instance, 2 persons working in unison or working in unanimity, they set about to commit offense, and then one person is murdering another person, and the other person is committing assault against another person. You understand? But is in the course of the same transaction. You understand? So they should be charged together. And then where 2 or more persons form a common intention, to effect an unlawful purpose, and an offense being the probable consequence and also done in furtherance of the unlawful purpose is committed in the course of that transaction, they are all liable and should be charged jointly. You understand? So where, for instance, 2 persons have set about to rob a bank. For instance, 2 persons have set about to rob a bank. And then when they go to the bank, their intention is to rob a bank. You understand? And then they go to the bank. Now, this particular exception is telling you now that any act done by any of them, which is in furtherance of that common intention, which is in support of their main agenda of robbing a bank, any act done by any of them in furtherance of that common intention or in support or in facilitation of that common intention is deemed to have been committed by the both of them. So they should be charged together. So we have, for instance, 2 people set about to rob a bank, and then on getting to the bank, they met the manager. They will usually, manager, open the safe, and the manager is stalling, and then one of them takes his gun and use the head of the gun, and hits the manager on the head. So stop wasting our time. If you do anyhow now, we'll shoot you on the leg. And the manager is still wasting time, and then one of them brings a gun and shoots the manager on the leg. Now, 2 offenses have been committed, or let me say 3 offenses. Attempt to commit armed robbery because they have not yet collected the money. Attempt to commit armed robbery, offense of assault, and then offense of offense of assault, and then you can say aggravated assault or whatever. You understand? So all these offenses that have been committed here now, you know that the common intention is to rob the bank, but they went there, the manager was misbehaving. One of them shot the manager in the leg, took his gun, the head of the gun, and hit the manager in the head. Now, all these things are probable consequence of the robbery, and it is done in furtherance of the purpose of the robbery. Understand? Because the manager was wasting their time. Understand? So they had to shoot him on the leg to know that they are serious. It's in furtherance of the common intention of robbery. So both of them are deemed to have committed that offense of shooting the manager in the leg. They will be charged together for that offense. Understand? It is immaterial that one person alone committed that offense, provided is in line, is in tandem with their common intention. They are to be charged together. And then where one person procures another to commit an offense, you understand? Maybe for instance, you're working somewhere and your boss is owing you for up to 12 months. He doesn't want to pay you, and you are disgruntled. You got a bad guy, an assassin, to kill him, and then the assassin ends up killing your boss, and the assassin is caught. You understand? You procure the person. You understand? You procure the person. You know, there's this Latin maxim. Is it qui facit per alium facit per se, something like that. He who does an act through another is deemed to do it himself. You understand? So this is the principle here. So both of you are to be charged together for that offense. And then another one is where for instance an offense is committed by one person and then another person abets the offense. You know what it means to be an abettor. That is, you're an aid. You know, you are abetted to the offense either before the commission of the offense. You help to provide ammunitions and all those things, knowing full well what they were using it to do. You provided the ammunition. You are supporting them, or maybe after the commission of the offense, you helped the person to escape. You know, you're an accessory after the fact. You are to be charged with that person, you know, together for that offense. And then offenses such as theft and criminal misappropriation of funds. One person is working as a local government chairman, and then he stole about 6 billion naira. And then you, knowing full well that the money is a stolen money, you told him, okay, wire the money to my account in UK. You understand? He wired the money in your account in UK. You know, so in that case, now if they are charging him for whatever misappropriation of funds, they also charge you. Also be charged alongside. You understand? You'll be charged alongside. And then we have person accused of committing an offense during a fight or series of fights, and then the persons who abetted such fight as well. You understand? So if people were fighting and you were busy encouraging the fight, you know, you're like, hey, take this block, hit him on the head, Use, you know, maybe your guy or your girl is fighting with someone, and you are persuading your girl to fight on, and you even give him a block. You know, you're assisting him to fight better. Both of you will be charged together for the offense of affray. Both of you will be charged together for the offense of affray. So now we look at the following points. So now when two or more persons form a common intention to effect an unlawful purpose, e.g. robbing a bank, any separate offense such as raping a secretary or stealing the managing director's wristwatch, committed by one person, not aiding, not in line, or not in any way furthering the original purpose, is charged separately against the offender in a different count. So now this is a very important important point that you need to note. You know, we have said something that when two persons set about to effect an unlawful purpose, that is to carry out whatever that is unlawful, such as robbing a bank, whenever any of them separately does any act which is a probable consequence or which is done in furtherance of the common intention of that, or the common intention or that unlawful purpose, that both criminals are going to be charged together for that offense. And I gave you an example of when a managing director, a manager of a bank, you know, he's stalling, he's delaying to open the safe, and then one person shoots him on the leg. Both of them are to be charged for that particular offense, you know, of causing grievous bodily harm. You understand? But now, what if one of them deviated from the common intention? What if one of them, you know, the intention is to rob a bank, and then one person saw a very beautiful secretary, and then he cornered the secretary into the toilet and had his way, you know, to have carnal knowledge of that secretary, are you going to expect the other robber, the other armed robber in the other room, who is busy telling the manager to open the safe? Are you expecting him to also be liable for the offense of rape? No, the answer is no. Understand? So that particular deviation, that particular act done by the other robber who raped the secretary is not in any way in furtherance of the common intention. It doesn't facilitate the common. It's not in support of the common intention. You understand? It does not in any way facilitate the common intention. So that offense of rape, only the person who committed the rape is to be charged for that offense of rape, but it's still going to be in the same charge sheet, but in a different count. You understand? So you can say count one, the offense of count one, the offense of armed robbery. You put the both of them there, and then count two will be for the offense of rape. You understand? The offense of rape now will now be for only that person who deviated to commit that act. And then one of the reasons it's still in a different charge sheet is because it is still in the course of the same transaction. The transaction has not ended. They are still in the course of robbing the bank, and then he committed the offense of rape. You understand? It could also be that in the course of robbing the bank, and then maybe he opened the drawer and then he saw a very beautiful gold wristwatch. The gold wristwatch belongs to the manager. It belongs to the manager, and then the manager is busy somewhere receiving a beating to open the safe, and then he picked the wristwatch and put inside his bag. You understand? That stealing of the wristwatch is not in any way in furtherance of the common intention. Now that is now the offense. That is the offense of stealing. You understand? That is stealing because the manager is elsewhere. The manager doesn't even know that his expensive gold wristwatch has been taken. Now that one is not in any way in furtherance of the common intention of robbing the bank. And then where they want to charge for that offense now, it will be against that person who committed that stealing, separately in a count, in a different count, but in the same charge sheet. You get. And then now the second point to note is that if the unlawful purpose concludes and is clearly evidence that is, a transaction has come to an end, any subsequent independent offense by a party is charged separately against him in a new charge sheet, provided it is unrelated to the original purpose. So now where the course of transaction has ended, they are done robbing the bank. Now let's take, for instance, two or more persons formed the intention to rob the bank, and they went there, they robbed the bank successfully, and they came back, like they have finished robbing the bank, the transaction has come to an end. And then why the transaction has come to an end, maybe they are driving back home, and then one of them, maybe they are driving back home, and then they had to maybe enter a filling station to refill their car sharply, and then continue driving back home. And then one of them there sees a very beautiful girl who is selling fuel, and then who went to ease herself, and then he followed the girl to the toilet, cornered her with his gun, and raped the girl there. Now this is the different transaction. You understand? This is more like a different transaction. Understand? This is more like a different transaction because they are done robbing the bank. They are done robbing the bank. So whatever independent offense you commit, and then the particular act of raping that girl who is a sales assistant in the filling station is not even in any way in furtherance of their common intention. You understand? It's not even in any way in furtherance of their common intention. You understand? They are done robbing the bank. That course of transaction in a way can be said to have not completely but partially come to an end. You understand? And then they just went to refuel so that they will continue going back to their home. And then that one now went to rape a girl. It's not in any way in furtherance of their common intention or whatever. You understand? So it should be a different charge sheet because the course of transaction can be said to have come to an end for the sake of that offense. But now there's something I want to bring to your mind. Now, what if in the course of driving back home, and then police officers now stop them? Police officers don't know them, but they just stop them. Hey, stop. We want to search your car. We heard that there was a robbery incident at so place. We are searching every car. And then maybe if police officers searches their car, they will see some bundles of money and guns that are stained with blood. And then in the heat of the moment, one of them brought out his gun and fired at the three police officers, creating way for the parties to drive on. Now, in that case, now that particular act of shooting the police officers can still be said to be in furtherance of their common intention. Remember, their common intention has been achieved, which is to rob a bank. You understand? But for the purpose of this shooting, it cannot be said that the course of transaction has completely ended. You understand? Because that shooting, that particular shooting is in a way protective of their common intention. Because if not for the shooting, police officers would have actually stopped them. You understand? So you have to. I know these things can be a little bit complex. You understand? These things can be a little bit complex, but you just have to try your best to understand them properly. But then we'll still look at some principles. You understand? There are some principles that will guide you. There are some principles I believe will guide you. And then before we talk about the tests on when to use a different charge sheet, I want you to note this thing. It's very, very important. Now, they say whether a transaction has ended is determined by the fact and circumstances. You understand? Whether or not a transaction has ended is determined by fact and circumstances. When you look at the circumstances of the case, then you will determine if the transaction has ended. One of the things that make a charge sheet running. When I say a charge sheet running, I mean you have drafted count 1 in the same charge sheet. You are drafting count 2 again. You are drafting count 3, count 4, count 5, count 6, count 7, count 8. You have not moved to another charge sheet. One of the main things that causes a charge sheet to continue running like that is the course of transaction. Provided that course of transaction has not broken, the course of transaction has not come to an end. In the course of robbing a bank, one person raped the secretary, you give him his own count alone. In the course of robbing a bank, the bank manager was shot because he was delaying, bring another count, all of them will be charged here. He's in line with the probable consequence and is in furtherance of the commission of the offense. In the course of robbing a bank, one of the robbers broke somebody's head because that person was trying to wrestle them down. All these things, you bring another count just like that. Now, why it is still in the same charge sheet is because the course of transaction has not yet ended. You understand? So whether or not a transaction, that is the course of transaction, has come to an end depends on the fact and circumstances. I gave you two examples. Now, you use the fact and circumstances to determine they have finished completing their common intention, which is to rob a bank. And then in the course of driving off, speedily, they notice, this car, they took no much fuel. They just zoomed into a filling station to just get fuel, in a very fast manner, so they can just move on sharply, no time. They are done with the bank. And then one of them now saw a beautiful girl, a sales girl, and then he followed the sales girl to the toilet and raped that sales girl there. Now, that particular act is not in any way related to their common intention of robbing the bank. And now I said, for the purpose of this offense, that is what I said. I believe that for the purpose of this offense committed, that person is going to have his own charge sheet. Understand? But imagine when he raped that particular girl, that sales girl. If the sales girl was a sales girl of that bank, in the course of robbing that bank, he raped that sales girl. He's still in the course of the same transaction. There's what we call continuity of action. There's what we call continuity of action. It was still in the course of robbing the bank that probably he raped the sales girl. It will still be in the same charge sheet, but in a different count. But now they have finished robbing the bank, and then they are trying to zoom away, but then no fuel in the car. Unfortunately, they had to enter into a filling station. While others are busy telling the person selling the filling station, be fast. One of them threw the back door, saw a sales girl, and went to rape the sales girl. Now, I'm saying that for the purpose of these circumstances, that person is going to have a different charge sheet. You understand? It's an independent action. You understand? It is an independent action. From this fact and circumstances, it can be said that there is no longer what we call continuity of action. There is independent action. And it is not just that there is no longer a continuity of action, but the second factor to consider is that raping the sales girl in the filling station does not in any way relate to the original common intention of robbing the bank. And then I gave you another scenario where maybe they are done robbing a bank and then they are trying to escape with a car. But then police officers start doing their stop and search. One person knowing full well that if they allow these police officers to search their car, they will see the bundles of money and bloodstained guns. And then one of them gets angry and then blows up the police officers with his gun, leading to the murder of the police officers. Now, in that particular case, it cannot be said that the course of transaction has ended. You understand? Because what he did in a way is still related to the original purpose. It's still related to the common intention formed to rob the bank. So what he did now is still in furtherance of the common intention. It is still going to be in the same charge sheet. You understand? That is why this statement here, according to Professor Nasir Tijani, look at what he said in this number 2. He said, if the unlawful purpose concludes and is clearly evidenced, the transaction ends. Any subsequent independent offense by a party is charged separately against him in a new charge sheet, provided it is unrelated to the original purpose. So shooting the police officer after they have finished robbing the bank in order to stop the police officer from searching their vehicle is still related to the original purpose. So it still has to be the same charge sheet. Understand? So you just have to think. Understand? You just have to think. And then now we are saying whether a transaction has ended is determined by fact and circumstances. And then this is one thing you must note. According to Professor Nasir Tijani, he said in the cases of robbery, for instance, that the transaction is deemed ongoing until the loot is shared. You understand? So in the cases of robbery, for instance, the transaction is deemed ongoing until the loot is shared. Now, I think when this statement applies more, this statement will apply more in scenarios that look like that of Patrick N. Jovins against the state. Yeah, the cases that look like Patrick N. Jovins. Imagine when, for instance, 2 or more people go to River State, they rob a bank, and then they have not shared the money. They go to Bayelsa, they rob another bank. They have not shared the money. From Bayelsa, they entered Kaduna, they rob another bank. They have not still shared the money. From Kaduna, they go to Lagos. So in that case now, for the purpose of even if they have finished robbing the bank in Port Harcourt, they have finished robbing the bank in Bayelsa, they have finished robbing the bank in Lagos, so I think this is statement now, this Professor Nasir Tijani statement will apply more in the cases where it is purely based on robbery. You rob this place, you go here, you rob here, you go here, rob here, but you have not shared the loot. But I believe on the authority of this statement, if they rob, for instance, in River State and share the loot, and then they go to Lagos and rob and share the loot, and then they go to Bayelsa and rob and share the loot, I believe what we are going to have is about 3 charge sheets based on the authority of this statement. But if they have not shared the loot in any of these 3 instances, then we are going to have 1 charge sheet. You understand? That is what I believe on the authority of this statement. So now we look at the parameters, we look at the test on when to use a different charge sheet. You understand? So in consequence of observation, I studied some of these things, and then I came up with the conclusion that there are about 4 parameters, about 4 guides. You understand? 4 pillars to look at before you move to another charge sheet. You understand? So now one of the pillars is that chain of causation test. You understand? The chain of causation test, that is more or less the course of transaction I've been talking about. Provided the course of transaction is still ongoing, you understand? There is continuity of action. They are still robbing the bank. You understand? There is this continuity of action. So the course of transaction test is one of them. So whatever that happens in the course of the same transaction, even if about 20 offenses occurred in the course of the same transaction, it has to be in the same charge sheet. You understand? And another one is the furtherance test. So if 2 persons go about to rob a bank and one person does any act which is in furtherance of the common intention, it still has to be in the same. It still has to be in the same charge sheet. You understand? It still has to be in the same charge sheet. And even if what he did is not in furtherance of the common intention, provided it is still within the course of the same transaction, it will still be in the same charge sheet, but in a different count. But if the course of transaction has ended and someone does any act that is not in furtherance of the common intention, then it has to be a different charge sheet for him. And then another thing we'll have to consider is the nature of offense committed. What is the nature of the offense? I gave a very practical example here. Two persons set out to rob a bank, and then they are done robbing the bank, and then maybe while they were trying to escape, they caught them. And then in the course of arresting and apprehending them, they found out that they are with some psychotropic substance like cocaine and marijuana. You understand? So being in possession of hard drugs, that one is a federal offense. You understand? And then the robbery, so why the robbery can be tried by state high courts, that of the offense of being in possession of hard drugs will be tried by the federal high court. So in that case, now you will now have to charge sheets. You understand? You will now have to charge sheets. And another one is the rule in Patrick Henjovins against the state. You understand? So by virtue of this rule, when an offense starts in one state, proceeds to another state, ends in the third state, you understand? There is no need for you to say, this offense has sprang across 3 states. That means there should be 3 charge sheets. No, they don't do it like that. By virtue of the rule in Patrick Henjovins against the state, it is possible that an offense can go through 3 states. You understand? It can go through 3 states. It doesn't mean it starts here, proceeds to another state, and concludes in the third state. Any of the states can try the offense, and what you need is just 1 charge sheet. You understand? And then now we look at, so I also made this observation. I also believe in consequence of the observation that if you look very well, that these are the factors that determine the number of counts. You understand? Like, for instance, you might be wondering, in this past question, these people drafted 9 counts. How did they come up with these 9 counts? You understand? You might be wondering, I spotted only 4 counts, or I saw only 5 counts. How come people are saying there are about 10 counts there? How are they doing it? You understand? So in consequence of my due observation, I came up with these parameters. So if you understand these 5 parameters very well, you will definitely know how to spot all your counts in an exam scenario. So now you ask yourself, the first consideration is the amount of offense committed. Now, what is the amount of offense committed? Somebody went to rob a bank. Let me say one person went to rob a bank. He succeeded in robbing the bank. He also raped another person and he murdered another person. Ordinarily, 3 offenses were committed. That is 3 counts. It's as simple as that, ABCD. Now, this is the basic consideration. And then another thing you check is the number of victims involved in the crime. You understand? Now the number of these victims is another factor you have to conclude. Now, this is very, very important in cases of murder. You might see a scenario where, in exchange of gunfire, somebody murdered 3 police officers. You understand? You cannot say count 1, murder of Okafor Cone, Kennedy, Okafor, and Chris Bryant. You cannot put in one count that they murdered 3 persons. No. Counts are per victim. You understand? Counts are per offense committed. Counts are per victim. Counts are per property tampered with. You get? So if, for instance, 3 people were murdered, count 1, murder of number 1 person. Count 2, murder of number 2 person. Count 3, murder of number 3 person. That is how you look at it. Firstly, ask yourself, what is the amount of offenses committed in this case? How many offenses were committed here? 2, against how many persons was this offense committed? Understand? One type of offense may be committed against 4 persons. You must provide 4 counts. One victim will have his own count. You don't say count 1 that this offense was committed against these 4 persons. No. One victim will have his own count. And another thing you have to look at is how many properties were tampered with. The number of properties that was tampered with. Now, this is usually the case for offenses of robbery, armed robbery, and stealing. You understand? So you need to ask yourself, how many property was tampered with? Remember, I told you, counts are per offense committed. Counts are per victims affected. Counts are per properties tampered with or property stolen or dispossessed of the owner. Somebody can have 5 iPhones. Maybe he's a dealer, he deals in iPhones. He sells refurbished iPhones to people. You understand? And then maybe he's coming back home and then he has about 5 iPhones with him. You get? And then somebody walks up to him, points a gun to him and say, give me those iPhones. And then he hands the person the 5 iPhones. You cannot come tomorrow as a state council and you say, count 1, armed robbery of 5 iPhones. You don't do that. Count 1, armed robbery of iPhone 7. Count 2. Even if it's iPhone 7 up to 5, you have to provide 5 different counts for iPhone 7. You understand? That is how it's done. The only thing you aggregate is money. Remember what I told you. The only thing you aggregate is money. If the person was holding like 3 bundles of money, 20,000, 20,000, 20,000, that is total of 60,000. You cannot say count 1, 20,000, one bundle. Count 1, 20,000, another bundle. No, you just aggregate it and say stealing of armed robbery of 60,000 naira is okay. But you don't aggregate property. Property count in property is per property tampered with or per property stolen or robbed. So if somebody was holding 5 iPhones, you have to provide 5 different counts for 5 different iPhones. And then at the same time too, if there were 2 victims of that offense, maybe 2 persons we are holding 2 persons are dealers in the iPhone. They do their business differently. You understand? There are 2 different businessmen and each of them were holding their iPhones. There are 2 victims involved. 5 iPhones each, 5 iPhones each. That is about 10 counts. You understand? So count is per victim, count is per offense committed. So just understand the scenario. There are 2 victims there. There are 5 iPhones each they were holding. The total of 10 counts. You draw up 5 counts for this person and draw up 5 counts for this person. That is how it's done. You understand? And then another thing you have to look at is the number of acts that was done against the victim. You understand? What are the number of acts that was done against the victim? Now I want you to remember that it is possible for you to kidnap a young girl. It is possible for you to keep that young girl in your house and also beat her up, assault her all the time. It is also possible for you to rape that young girl that was kidnapped at will. How many offenses has been committed now against that young girl? How many acts have you done? You have done 3 gruesome acts to that girl. You kidnapped her, you assaulted her, that is by beating her, and then at the same time you raped her. You understand? She's one victim, but you have done 3 acts to her. Now those 3 acts are to be provided in 3 different counts. You cannot say count 1 that you kidnapped, raped, and assaulted one Felicia. No, you have to differentiate them. Count 1, kidnap of Felicia. Count 2, rape of Felicia. Count 3, assault of Felicia. That is how it's done. Understand? That is how it's done. And another one is a deviation from common intention. You understand? Whenever there's a deviation from common intention, provided is in the same course of transaction, you have to provide. Just know that you need a different count. You understand? You have to provide a different count for that person who deviated. You understand? So if you know these factors, if you understand these factors very well for drawing up different counts, you see that you can never miss your counts again. You can never miss your counts again. You're practicing your past question, you're practicing your draft, you can never miss your count again. You understand? And then if you're drafting your charge as well, first thing you have to do immediately you get your script, look at the punishment section, circle the punishment section. Circle only the punishment section. You understand? Because it is a punishment section that determines what you charge for. You understand? Those punishment section in your booklet are assumed to be the existing law of the state. You understand? It is possible that, for instance, in the scenario, the person was assaulted, but there's no punishment section for assault. You don't charge for assault. Now, you will not charge the offender for assault, provided that there's no punishment section for assault. Now, the implication is that it relates to Section 36 sub 2 of the Constitution. You cannot charge and try a person for an offense that is not defined and is penalty prescribed in a written law. So those punishment sections that are provided to you in the exam, it is assumed that you're a state council, and those are the laws existing in the state. You understand? So if from the scenario the person assaulted his victim, and there's no punishment section for assault, it simply means that in that state you are charging the person, assault is not an offense. You understand? So first thing you have to do is to circle the punishment section. So because the punishment section will determine most times the range of offenses you're going to charge the person for. And then after that, the next thing you do is to read it. Just read the scenario just once. Read your scenario. Just read it like you're reading comprehension. You understand? You don't need to underline at first. Just read it from beginning to the end. Read it as if you're just reading a comprehension. You understand? Like you're reading for the purpose, like an English passage for comprehension. Read it from beginning to the end, and then come back again and start reading it line by line. If you read line 1 and you notice an offense in line 1 which has a correlative punishment section, immediately write it down somewhere. You understand? You can have a rough, maybe at the ending part of your script or at the beginning part of your script. You understand? Just write it down somewhere. Count 1, you put down the offense. If you read line 2 again, if you notice any offense committed, immediately put it again. Count 2. You can even put just put it count 2. You read the third line again. Now I don't know if I know you can't see me physically, but from my words you should understand what I'm doing. You have already read the whole scenario the first time as if it's an English passage. You understand? No need to underline anything. But now you start again. You will now be reading it line by line. You understand? So if you read line 1 and you see an offense has been committed and that offense has a punishment section, go to your draft and put that offense as your count 1. You understand? And then move to the second line. Don't move to the third line. Don't move to the fourth line. No, remain in that second line. Look for any offense in that second line again. If you see an offense in the second line, go to your draft, your rough draft, and put that offense again as count 2. If you go to the third line and you see an offense again, and then as you're checking this thing, take note of how many persons it was committed against, how many properties was tampered with. You understand? How many acts was done against a person? Because from one particular line, you might see that they murdered 2 police officers. So in that line you are reading, 2 offenses has been committed, necessitating 2 counts. So you know you provide 2 counts in your rough draft. It could be count 3 and count 4. Understand? So that is what you do line by line, line by line, line by line, line by line until the last line. Understand? So at the end of the whole day, you see that you have captured all the counts. You cannot miss any count. Like if there are about 9 count or 8 count, you have captured all the 8 counts. And then what you just have to do again is to read the scenario again. Just for if you like, you can just read the scenario again and then start drafting your charge sheets. You understand? Drafting your charge is not something you'll be in a hurry. I know there's no time. It might take you up to 45 minutes or 30 minutes or 40. Some people 1 hour to draft a charge, but it is better. It's better for you to draft a charge completely than for you to go and draft nonsense, in the name of being fast. So look at the last rule. The last rule is misjoinder of offenses. So by this rule, what this rule is simply saying is that for every charge sheet, that there should be 1 offense. You understand? 1 offense for 1 charge sheet. So that is what this rule is saying generally, that there should be 1 offense for 1 charge sheet. 1 full charge sheet, you should just have 1 offense. 1 full charge sheet, 1 offense. That kind of. But there are exceptions. There are instances where you can have more than 1 offense in 1 charge sheet. You get? So when one person has committed different offenses within 1 year, you understand? All those offenses he committed within 1 year should be contained in that charge in 1 charge sheet. Charge sheet is different from count, so please, you understand? Some people will say, there is no difference between the rule against misjoinder of offenses and is it duplicity or something like that. People will usually say that there's no difference between the rule against duplicity and the rule against misjoinder of offenses. That's not true. Misjoinder of offenses relates to charge sheet. That is the whole document itself. This misjoinder of offenses is saying for 1 full charge sheet, you should just have 1 offense. You can imagine the rule appears a little bit stupid. For 1 full charge sheet, you should have only 1 offense. So in a whole charge sheet, for instance, you will just see count 1, Okafokon committed murder. And then you then go to another charge sheet and see count 2. Go to another charge sheet to see count 3. You understand? You waste a lot of paper now. You understand? So that is the essence of the rule against misjoinder of offenses. But the rule against duplicity relates to count. It relates to a count inside of the charge sheet. The rule against duplicity is saying for every count, one offense. Count 1 should be one offense. Count 2 should be one offense stated. Count 3 should be. So even if you have 10 counts, that 10 counts, you have only 10 offenses stated in each respectively. That is the essence of the rule against duplicity. Why the rule against misjoinder of offenses is talking about charge sheet. A whole charge sheet should have only one offense, count 1. Then the next charge sheet should have count 2, just like that. So they are not the same. Why the rule against duplicity relates to count, the rule against misjoinder of offenses relates to a charge sheet. They are not the same. Don't say that they are the same. So we are talking about exceptions to misjoinder of offenses. One of the exceptions, we said that when one person commits different offenses within 1 year, all those offenses committed within 1 year should be contained in one charge sheet. Although according to Professor Nasiru Tijani, he said, where, for instance, someone committed 5 offenses within 1 year, that you should take only 3 of those offenses and put in one charge sheet, and then the remaining 2 should go to another charge sheet. So this is more like an exception to the exception. And then there are offenses that are constituted under 2 statutes. You understand? There are offenses that are constituted under 2 statutes, and they may be contained in one charge sheet. It is possible that, for instance, a person committed the offense of rape, and then you charge him count 1, rape contrary to the Criminal Code Act. You charge him count 2, rape contrary to Section this of the Violence Against Person Prohibition Act. You understand? Because that offense is constituted under 2 statutes. You understand? Under 2 legislation. Then you can then bring 2 counts. You understand? You can then bring 2 counts. So in this case now, as an exception to the rule against misjoinder of offenses, there will be no need for you to say one charge sheet count 1, rape under Criminal Code Act. Another charge sheet count 2, rape under Violence Against Person Prohibition Act. You can bring them and put them in the same charge sheet. But the court can only convict the defendant for one. You understand? The court can only convict the defendant for one. Most of the time, why prosecutors do this is that, for instance, you might say, if I charge this person for rape under the Criminal Code Act, he might escape. Maybe the definition of rape under the Criminal Code Act is very relaxed. You understand? It's not stiffer. It's not tight. You might say, if I charge him only for rape in Criminal Code Act, he might escape. Let me add the one under Violence Against Person Prohibition Act, because it's more stringent. If he escapes this one, he won't escape the ingredients or the elements in this other one. That is why prosecutors do that. And then there are certain acts constituting one offense, but when combined together constitute a different kind of offense. You can see the example here. Got him from Agaba. And then offenses committed in the same course of transaction. So just like we have in those other rules against duplicity and misjoinder of offender. So where offenses, for instance, 3 or more offenses are committed in the same course of transaction, there's no need for you to draft 3 charge sheets for 3 offenses that are committed in the course of the same transaction. Just put it in one charge sheet. Why put it in 3 charge sheets? And then offenses of a similar or identical nature. When offenses committed by a person is similar or identical, there's no need to put them in a different charge sheet, respectively. There's no need for that. They should just be put in one charge sheet. Since they are similar, you just separate them, count 1, count 2, count 3, count 4, count 5 in one charge sheet is enough. And then where the prosecution is doubtful, the prosecution is not sure. The prosecution is not sure what particular offense he's going to secure the conviction of the defendant for. For instance, imagine when a defendant committed, maybe for instance, prosecution is like, this offense that the defendant committed, is it obtaining by false pretense, or is it stealing, or is it cheating, or is it cyber fraud? The prosecution is like, I don't even know what to charge this guy for. And if I charge him for one now and I'm not able to prove the elements, this guy will go scot-free. Okay, it's better. Let me just charge him for all of them. And then anyone I'm able to prove the elements, then they will convict him for that one. So In this case now, there's no need to separate them. They say charge, for instance, now you say this charge sheet is for offense of stealing. This charge sheet is for offense of fraud, cyber fraud. This charge sheet is for the offense of cheating. This charge sheet is for the offense of obtaining by force. No, just put all of them. You just have to put all of them in the same charge sheet. You understand? Just put all of them in the same charge sheet, and then maybe you can separate them based on count. Count 1, cheating. Count 2, fraud. Count 3, obtaining by false pretense, and all that. And then now we go to withdrawal from the commission of an offense. Now, we know there's something called countermanding. You understand? There's something called countermanding. You get? So before the commission of an offense, somebody can withdraw. You understand? A person can withdraw. You understand? Maybe his mens rea is no longer with him. He no longer has intention to commit the offense. He can withdraw from the commission of the offense. But there are conditions for withdrawal. A person's withdrawal must be clear, unequivocal, and direct. If you are withdrawing, you must make it clear to your co-robbers that you are withdrawing. State it clearly, positively, that you're withdrawing and you are no longer willing to follow them to rob that bank. You understand? And then you must communicate that your withdrawal expressly to your co-robbers, to your other parties. And then it should be communicated before the commission of the offense. You understand? It should be communicated before the commission of the offense. So, for instance, now they cannot be waiting for you in order for you people to go and rob a bank on a Sunday afternoon, on a Tuesday afternoon, and then maybe they didn't see you, and then they just went on their own to rob the bank, and then maybe after robbing the bank, you're not telling them that you have withdrawn. No. Instead, they are more like they're more like angry with you. Like, where were you? You're supposed to follow them for this operation, and then you're telling them that you withdrew. That is why you can't be telling them you withdrew after they have already set in motion. You must have to withdraw before the commission of the offense. And then the mens rea of the withdrawal must be in tandem with its actus reus. You understand? I gave an example. Imagine we have, for instance, a co-robber by name Gabriel Okoye. He's like, after the crusade last night, maybe he's telling his co-robbers, for instance, Gabriel Okoye, for instance, now is a co-robber to 4 others, and then he's telling them, look, after the crusade last night, I was touched by the Holy Spirit. So I don't think I'll follow you people to rob the bank again. You understand? But as Professor Nasri Tijani puts it, he said the co-robber will then tell his other co-robbers that, but I'm with you in the spirit. You understand? So in that case, how can you say you're withdrawn and then you're with them in the spirit? Some persons will even go ahead to say, I don't want to follow you to commit the offense again, but the economy is hard. I will see go chop. That kind. So when you make this statement, it just simply shows that your actus reus and your mens rea are not in tandem. You understand? They're not alike. You may have withdrawn in terms of your actus reus. You don't want to follow them to do the act, but your mind is still with them. That is not a valid withdrawal. And then I want you to also know that the fact that the person missed his flight is not to say withdrawal. For instance, you are supposed to follow them to rob a bank in Lagos, but you could not meet up, you missed your flight. That is not withdrawal. You cannot say that you have withdrawn. You will still be liable for the offenses they commit. Understand? And then it's relevant to know that when a person has withdrawn, he will still be liable. Like when a person has validly withdrawn before the commission of the offense, he withdrew, his withdrawal was positive, affirmative, clear, expressly communicated, the person will still be liable for conspiracy to commit those. Conspiracy itself is an offense in our criminal jurisprudence. The fact that you have conspired, you have formed a common intention with some persons to perpetrate a crime is an offense, you understand? So even if you withdraw from the substantive offense, you will still be charged for the inchoate offense of conspiring with your co-robbers to commit robbery. So now you might ask yourself, how do we charge the offense of conspiracy? For instance, like I said before, if the punishment section is provided, then you should charge the person for. Sometimes in the scenario, you might see a scenario where they say they gathered in a house and planned how to execute a robbery. Look for the punishment section. If the punishment section provides for conspiracy, then that will be the first count. That will be your count 1. That will be your count 1, conspiracy. But if the punishment section does not provide for conspiracy, don't mind the scenario. Don't charge for conspiracy. So now, if you want to charge for conspiracy, how do you draft the charge? You understand? According to Professor Nasri Tijani, say in your statement of offense, you just say conspiracy to commit a felony. You understand? But then I heard from some persons in Port Harcourt. I think during my time in Lagos campus, some persons in Port Harcourt said something like conspiracy to commit a felony to wit murder. You understand? For instance, maybe the what they want to commit, for instance, is robbery, armed robbery, whatever. You can just say count one, statement of offense, conspiracy to commit a felony to wit armed robbery. Understand? So that was how one of my friends told me they were told. I think so. But in my campus, they just said conspiracy to commit a felony. So whichever way, you're okay. And it's relevant to note that where a person procured has taken step to commit the offense, plea of withdrawal shall not suffice. So where, for instance, let me say, for instance, you're a boss, you're more like an Escobar, a boss, a Pablo. You arrange people to commit armed robbery, and then the person you procure to commit armed robbery has already gone to commit armed robbery. You cannot be saying, I withdrew. Like I told him to, I told him to abort. I told him to stop. I told him not to go again. You should have said that before he committed the offense, not when he's in the course of committing the offense. You understand? But then imagine a scenario where, for instance, a boss, like a Pablo or an Escobar, like a boss, procured some persons to commit the offense of armed robbery. You understand? Procured some persons to commit the offense of armed robbery. But before they committed the offense, he clearly told them, abort. Don't commit the armed robbery again. You understand? All of you should stop. All of you should withdraw. Don't commit the offense of armed robbery again. Abort. And clearly, those persons had the opportunity to abort. You understand? They had the opportunity to abort. They have not already set in motion the offense of armed robbery. They had the opportunity to abort, but they still went on to commit the armed robbery. Now, in that case, the person who procured them cannot be liable for the substantive offense. He can only be liable for the offense of conspiracy. So now we go to who can amend the charge. Ordinarily, it is that person who drafted the charge that can amend the charge. So, for instance, in magistrate courts in the South, police officers can amend the charge because they draft the charge. And in the High Court, the Attorney General, represented by state councils, can also amend the charge drafted by them. You understand? And then the courts as well can sometimes amend the charge, usually in the interest of justice. They can on their own amend the charge. You might ask yourself, when is it even necessary to amend the charge? You might want, it's possible. You might want to amend the charge. I told you when we are talking about institution of criminal action, we looked at nolle prosequi and we looked at withdrawal of charges. Yes, and withdrawal of charges could be in whole when when the prosecution wants to withdraw the whole case, or he might want to withdraw a particular count. Say he doesn't want to prosecute the offender again for count 1. He wants to retain only count 2, 3, and 4. So in that case now, how does it do that? He has to amend the charge. He has to make an application to the court to amend the charge. He has to make an application to the court to amend the charge, usually by way of motion, you understand, to amend the charge. So the courts can still on their own, in the interest of justice, suo motu, on their own volition, amend the charge. They can still on their own amend the charge. But such an amendment must be a continuation of the old charge and not a new one existing side by side, with the old charge. And then you can ask, what are the types of amendments? We have 2 types of amendment of charge. And these 2 types of amendment of charge translates to the stages of amendment. Understand? So we can amend a charge to which we are using to prosecute a defendant either before we arraign him or after he's arraigned. You understand? So these two different types of amendment has different procedures, and then they also have their consequences. You understand? So before arraignment, before you arraign a defendant, the prosecution can decide maybe the defendant is supposed to be arraigned. Let me say, for instance, on the 14th day of August 2025, and then today is the 7th of August, and then today is the 7th of August. You understand? Usually before you people come to court, you people must have filed all your documents. In civil litigation, we call those things pleadings. You understand? So you people must have filed, the prosecution must have filed his charge in court and done every other thing. You understand? He must have done every other thing. So in this case now, before the person is arraigned, he can decide to, oh, I want to withdraw count one. Before we bring this guy to court, I want to withdraw count one, and then put another count, to replace it with another count, or I want to withdraw count one totally and go with only count two and three, something like that. Understand? So in this case now, he can do it orally before the court. You understand? He doesn't need to file any application before the court. All he has to do is just draft and prepare a new charge or a new information. He files the new charge or the new information in court before the date of arraignment, and then he will have to address the court. He will have to address the court to arraign the defendant based on the new charge or information, and then the court will just automatically abandon that first charge or information, and then the defendant will then be tried with the new charge. And then at the date fixed for hearing, the defendant will then take his plea on the amended charge. You understand? But however, it's relevant to know that the court will not allow any amendment that is intended to cause injustice to the defense. The court will not allow any form of amendment that is intended to cause injustice to the defense. But then now, when the defendant has already been arraigned in court, and then the prosecution wants to amend the charge against him, it's possible that maybe they have done a first hearing, and then this is the second hearing of the case, and then the prosecution now wants to amend this charge. Now, in this case, he cannot do it by orally addressing the court. He must have to come by way of an application. He must seek the leave of the court, and we know the procedure. You have to go by way of motion. In this case, by way of motion on notice, supported by an affidavit and a written address. And then he has to attach the copy of the amended charge sheet on the affidavit. You understand? He has to attach. He has to attach an amended copy, like that amendment he wants to make. You understand? That amended charge that he wants the court to use and abandon the old charge. You attach that new charge sheet in the affidavit. You attach it as an exhibit. Anything you attach to an affidavit, you usually make reference to it in that affidavit as an exhibit. You understand? So he's going to attach it to the affidavit as an exhibit. So this is the procedure he's going to follow. If he follows any other procedure, it's a nullity. You understand? And then there are procedures after amendment. Now, after amending that charge, there are certain procedure. You understand? For instance, that amended charge has to be read and explained to the defendant. You understand? Because the defendant is already conversant with the old charge sheet that was being used to prosecute him. That was the one he pleaded guilty or not guilty, and then all of a sudden, he's seen a new charge sheet. You understand? He received a notice of a motion which the prosecution is moving to introduce a new charge sheet. So in this case now, you have to read and explain the new charge sheet to him. You understand? The registrar has to read and explain again the new charge sheet to him. And then he'll be required to take a fresh plea on the new charge sheet. That is, whether he's guilty or he's not guilty. For instance, it could be that a new count has been added. You understand? So if a new count has been added to the new charge sheet, he will have to plead whether he's guilty or not guilty to the new charge sheet. And then the court will then inquire from the defendant if he's ready to be tried on the fresh charge. You understand? And then the court may grant an adjournment. If, for instance, looking at the new count, maybe the new count is a very serious count, maybe the offense of murder, the court we have to look at the situation and determine whether or not they can continue today, or maybe the defendant, there's this right a defendant has. He has a right to reasonable time and facilities to prepare for his defense, you get. So if, for instance, the new count they added is a very serious count that will cause the defendant to be convicted for murder and be sentenced to death, you understand? So if, for instance, it might be against the interest of the defendant or even against the interest of the prosecution to continue with the trial, the court will usually adjourn, you understand, enabling the defendant to prepare for his case. And then the court will now endorse a note, on that charge. I said, on the new charge, the court will have to make an endorsement showing that the charge was amended. You understand? Oftentimes, amendment on all these documents, you usually read amended this dash of dash pursuant to the order of justice dash of the High Court of Lagos State, this dash of dash. You understand? So you have to endorse a note on the charge. And then upon this now, parties shall be allowed. One major consequence of amendment of charges after the person has been arraigned is that parties will usually be allowed to recall witnesses again. When the prosecution amends the charge sheet and introduces a new count, such as murder, he will start calling witnesses to prove that is the murder case. The new murder case he has brought up. He has to call witnesses again. He might call new witnesses in relation to that murder count. And then in consequence thereof, the defendant will also be allowed to call his own witnesses to disprove that charge of murder. So failure to comply with this whole procedure now is what we call post-amendment procedure. And failure to comply with this procedure may actually impugn on the validity of the trial. And then it has been asked, is the post-amendment compliance requirement absolute? Like, is it mandatory? Is it compulsory to comply with all these post-amendment procedure? You understand? So Agaba actually argued that that with a non-compliance with the procedure, with any specific procedure, whether it is going to negate, whether it is going to vitiate trial, will depend on the weight of that particular post-amendment procedure. You understand? So the implication thereof is that I think we have about 7 post-amendment procedures. The implication thereof is that it is not necessarily the violation of all of them here that will actually officiate the trial. You understand? For instance, I myself opined that if the judge, for instance, failed to endorse the note, he doesn't go to any issue. That's just a mere irregularity. You understand? But imagine if, for instance, the new charge or the new count that was introduced was not read and explained to the defendant. You understand? That's more like a fundamental error. You understand? In Uketa and Sefaren, that is a fundamental error. When the new count introduced in the said charge sheet was not read and explained to the defendant, so he doesn't even know the offense for which he's been tried for, and he has not been asked to plead, to take a fresh plea on that new count. That is a fundamental defect capable of rendering the trial a nullity. You understand? But it's totally different when the court fails or forgets to make an endorsement on the charge. So now we might ask ourselves, what is the effect of a defective charge not amended? Now, if a charge is defective and then the prosecution failed to amend it, maybe a charge is ambiguous and then the prosecution failed or neglected to amend it. Now, what is the effect? Now, the effect of this is also the same with what we have been talking about. When it has to do with errors in a charge, defects in a charge, the effect will usually depend on what I've been saying. The weight, the gravity, the materiality of the error. Those defects are error. But another question the court will ask is, what is the materiality? What is the effect? What is the weight? What is the gravity of the error? Is it so material? Does it misdirect the accused as to occasion or cause miscarriage of justice? If it does, then that charge sheet will be set aside. But if it does not, trial is going to commence. You understand? And now, what is the effect of not signing the charge? The Attorney General has to sign the charge, either himself or through a state counsels or principal counsel. So what if a charge is not signed? It's been held that a charge that is not signed is a nullity. You understand? It's at best a toilet paper which cannot be used to ground conviction. You understand? So in the next this thing we'll look at bail pending trial. You understand? So we are in this class. I think we have seen how to draft charges, both the form and the substantive aspect of it. So in the next class, we'll know if Musa is entitled to bail. You understand? We'll know if while we are planning to arraign him, we are planning to arraign him. We have drafted the charge sheet. So now we are planning to arraign him. But before we arraign him, we are going to see if he's entitled to bail. You understand? Can Musa apply for bail and have his bail granted? You understand? That is what we are going to look at in the next class.